Well, hi, it's a pleasure. Thank you so much, and thank you to the Clery Center for sponsoring and putting on this great series of training. Good morning and good afternoon, depending on where you're calling in from. I just wanted to give a little bit of background information on me. I am an attorney at the Fairburg National Law Group, and I have been practicing for about 15 years. I have kind of a unique perspective, I think, because I've represented defendants, corporate defendants for about half of my career, working at Skadden Arps, big law firm in New York. And for the second half of my career, I've really been representing plaintiffs. And I'm an attorney, I'm an advocate. I do represent survivors of sexual assault and harassment. I represent survivors both at the university level and in the K through 12 setting. I also am very passionate about training. I believe that training on these topics is one of the most effective and best ways to prevent sexual violence, and I think we're all joining in on that effort. And thank you to all of you for attending this training. Kudos to all of you. As a disclaimer, because I am an attorney, of course, I'm gonna just state a quick disclaimer. I am an attorney, so if you do have any questions or any of the information I provide to you is not to be considered legal advice. But I would be happy to answer any questions you may have, sort of with that disclaimer in mind. I said I represent survivors. I represent survivors at both the sort of the level in the university disciplinary proceeding setting, you know, when students are going through that whole process. I also represent students in bringing complaints to the Department of Education's Office for Civil Rights. And I also have been involved in civil litigation. And when we start talking about the Clery Act and Title IX, Title IX is really the area where you see civil litigation, and there are different standards at all three levels that I just discussed. So when we're talking about the campus disciplinary proceedings versus civil litigation, there are different legal standards and regulations that come into play, or a different interpretation of Title IX. So I'll go through that. The presentation today, I hope that no matter what your level of experience is or training with respect to Title IX and the Clery Act is, I hope that this is helpful for you today. I provided basic information, some case law sites, because I am an attorney. I can't resist, but also reference materials. So I have, especially when I'm going to go through some of the statistics and data regarding sexual assault and violence, I provided citations to studies, and articles that provide backup information. Also, I would direct your attention to the Clery Center's wonderful resources, and the Department of Education also has a lot of guidance and resources available on its website. So during the presentation today, I want to discuss the legal framework surrounding students' rights and universities' obligation with respect to sexual violence and harassment. And this is going to include dating violence, domestic violence, and stalking, which were recently sort of incorporated into the Clery Act with the 2013 VAWA Act. I also want to, as many of you are probably know or probably familiar with, just this last Friday, the Department of Education withdrew some fairly significant guidance that was specific to sexual violence. That was the April 4th, 2011 Dear Colleague letter and the April 29, 2014 questions and answers on Title IX and sexual violence. So we'll talk about that, and we'll talk about the guidance that still is in place, and that we believe doesn't really, just because this guidance was withdrawn, we don't believe that the sort of the regulations and the best practices and standards for addressing sexual violence have really changed very much. And then at the end, I want to review the key requirements of the Clery Act and Title IX law and guidance. Excuse me. There are some overlaps But the Clery Act and Title IX are also very different in some respects, and also with regards to what they require. So I want to go through that, and I'll just go through a couple hypothetical scenarios designed to kind of to bring out the key areas. And before I actually launch into my presentation, I believe that Laura from the Clery Center wants to just go over some of the basics regarding the Clery Center itself.
Hi, Monica. Oh, thanks so much. Yeah, this is no real need to go through all this in great detail, but we just like to start our NACSAM webinars with a brief reminder of the reason why the Clery Center is here and why you all are here today. We do our work in memory of Jean Clery, who was the daughter of Connie and Howard Clery, the founders of Clery Center, and the reason that the Clery Act is in place. Jean Clery was a student at Lehigh University in April of 1986. She was a first-year student there when she was sadly raped and murdered in her dorm room. And her parents, in response to that loss, learned that there had been a lot of crime going on at Lehigh University that went unnoticed or unreported just because there were no standards or requirements in place at that time to do so. So Connie and Howard worked at both the local and state level first to develop legislation that we now know today as the federal consumer protection law that is the Clery Act. And then they also founded the Clery Center, which is a nonprofit training organization that is dedicated to working with colleges and universities to create safer campuses. We really value the work that we do in partnership with institutions of higher education to help them learn both the letter and spirit of the law for implementing it both at that functional base level, but also to really function with mind and heart behind all of the actions and institutionalization of compliance with Clery. So this year's NACSAM's theme of taking the first step is designed to address that idea that sometimes this work can feel overwhelming, or you might not even know where to begin or start, particularly if Clery compliance work is an add-on responsibility for your role at your institution, or if your institution just isn't as aware of the level to which Clery Act compliance needs to be executed, especially in light of the most recent VAWA amendments to Clery. And so we recognize all of that, and we want to encourage you this month, even as we end this week, to take the first step with us in looking through a lot of the free professional development resources we have created and provide to you throughout the month. We do have this series of webinars, and the last of those is this Thursday, and you'll receive some information on that also at the end of the webinar. There's also our NACSAM website, which is nacsam.clerycenter.org, where you will find links to recordings of the webinars that have already happened, in addition to the free resources that we have created this month, which include a facts document, a two-pager on the Clery Act summarizing it, in addition to some roll call videos that were created in conjunction with Allied Universal. So please take some time to explore that website and also explore the resources that we have to offer. And now we really are excited for Monica to take it away and to provide some more information to you all about the legal side of things with both Title IX and Clery. Thanks so much, Monica.
Thanks, Laura. So one of the things I like some clarity. We all want to know what are we really talking about today, and I am addressing sexual violence today. Title IX does incorporate other types of sexual harassment than just sexual violence. But what I'm going to concentrate on today is sexual violence, and we all hear a lot of different terms, and I wanted to sort of address that because sometimes we sort of meld all of this into just one term, and so like I said, we're talking about sexual violence, and there's overlap between sexual violence and with respect to the Clery Act that involves rape, sexual assault. Title IX talks about sexual harassment a lot, and as we'll go over in the presentation, sexual harassment is sexual violence, and it is rape, and it is sexual assault. We'll talk about incapacitation and physical force as we go through the statistics in the coming slides. We know that, though there's a saying, and I don't mean to be crass, but there is a saying that with respect to rape, who needs force when you have alcohol. So we know that the vast majority of survivors have been raped or sexually assaulted when they were incapacitated due to drugs or alcohol, or they were asleep. They were basically unconscious. We're also going to talk about dating violence, intimate partner violence, and stalking. And we'll go over definitions for those things. There may be overlapping definitions between the Clery Act and Title IX. And I know that at a lot of universities, all of this misconduct may fall into one category, which is sexual misconduct. So I think it's important that we understand what the terms mean, and that in your day-to-day work, you also understand what that means, what falls into that category of sexual misconduct. And again, I just want to emphasize that there are other forms of sexual harassment that are prohibited by Title IX, and we're not really going to address that today. But those are things such as gender stereotyping. But again, we're just addressing the sexual violence aspect of sexual harassment that is prohibited by Title IX. And we do know that sexual violence is a nationwide problem. And I think it's helpful to go over these statistics. Sometimes if you work in this field a lot, it's possible to get a bit desensitized. But what I really want to show or emphasize with regards to these numerous statistics, and I don't mean to just throw numbers at you, is number one, the really horrifying prevalence of sexual assault. Number two, to talk about which students are most at risk. Number three, talk about knowledge or what we understand about perpetrators of sexual violence, and also to address some of the myths about perpetrators. I also want to emphasize that the reporting rate is really low, and that and address another myth, and that is that women cry rape, or that there's false reporting of rape. That rate is actually quite low. So I won't go over all of these statistics in detail, but we do know that every 21 hours rape occurs on an American college campus. 1 in 5 women have been sexually assaulted while in college. There was some recent skepticism about that number, but it was actually confirmed just recently by the Washington Post Kaiser Foundation nationwide survey in 2015. So we know that number, which is, again, horrifying, is accurate. 1 in 16 men, that's supposed to be men, not means, 1 in 16 men are sexually assaulted while in college. And of all the age groups, females in that college age bracket, the 18 to 24, they have the highest rate of rape and sexual assault compared to women in other age groups. So again, it's a huge problem, and it's especially a huge problem when we're talking about college-aged women. We know that the average annual number of women who are victims of rape or sexual assault is approximately 31,000. 9 out of 10 victims know their perpetrator. I think that there may be a myth, and I hope this is outdated at this point in time, but rape and sexual assault is usually not committed by a stranger. It's very often committed by a boyfriend or an acquaintance, somebody that the victim actually knows. The reporting rates are very low. Only 28% of sexual misconduct involving penetration, so that would be rape, are reported to any type of organization like a Title IX office or law enforcement. And we also know that the rate of false reporting for sexual assault and rape is approximately 2 to 10%, and that number, again, has been confirmed by many studies, many reports, and I've included a citation to an article regarding that rate. And also, we know that false rate of reporting is consistent with the range of false reporting of other crimes. So when we sometimes hear the myth that women cry rape or falsely report. And again, I'm saying women because they are the majority of victims are women. That is really a myth that needs to be dispelled and should have been dispelled quite a while ago. We also know that there are extremely devastating consequences of rape and sexual assault. Up to 40% of victims contract an STD, and that includes HIV or HPV, which can lead to cervical cancer. 1 to 5% of victims of rape become pregnant, and there are 32,000 rape-related pregnancies in the U.S. annually. That's a number that has been recently confirmed by the Center for Disease Control. We know that women in abusive relationships report the highest rate of rape-induced pregnancy. We also know that 4 out of 5 of the victims suffer chronic physical or psychological conditions, and that can include everything from chronic pain, gastrointestinal disorders, as I mentioned, cervical cancers, migraines. The psychological impact can also be very severe. Victims of sexual violence often experience shock, denial, confusion, shame. A lot of victims suffer from post-traumatic stress disorder, and the numbers here show that the victims of sexual violence are more susceptible to suicide attempts, PTSD, serious depression, and substance abuse than non-survivors or non-victims. We also know that sexual violence can have major consequences, and with respect to the social impact on victims. Very often, victims suffer strained relationships with their family, their friends, intimate partners. They may withdraw. They have a lower likelihood of marriage. They may suffer problems with their intimate relationships, and very often they suffer from isolation from their family or community. And we also know that with respect to education, we see victims, their academic performance often declines. They may withdraw for a semester or entirely from school, and sometimes victims who don't feel that they've been supported will often transfer to different universities. I was an economics major in college, so I think that we can all also appreciate the economic consequences of this problem. In 2017, rape cost the victim $87,000 to approximately $240,000. If you haven't seen it, there's a very interesting and compelling article in the New York Times from 2016. It's called "What One Rape Cost Our Family," and it's the mother of a young woman who was sexually assaulted in college, and she itemizes the cost to their family in terms of their daughter's lost wages. She would have graduated from university a particular year, and she didn't, and spent a lot of time in treatment. And so she was able to quantify her daughter's lost wages. She also indicated her own lost wages, as she was a family member who, flew across the country to assist her daughter after she reported sexual assault. There was lost tuition. Her daughter withdrew from school. There were therapist bills. Her daughter did suffer from substance abuse after being assaulted, so there were also rehab and treatment costs, travel costs, and she estimated that it cost her family approximately $245,000, which she pointed out is equal to the cost of 4 years of tuition at some universities. As of 2007, rape carried the highest annual victim cost of any crime, and it costs approximately $127 billion per year. There's a very recent study that came out in 2015, and it's included in a slide that's in the presentation entitled Sources. The survey was a report on the Association of American Universities Campus Climate Survey. And I provided a link where that's available, but these statistics mostly come from that very recent survey. And what we know based on the survey itself and the report is that transgender, gay, queer, and nonconforming individuals and women face the greatest risk of sexual assault and misconduct at universities. We also know that undergraduates face a higher risk than graduate students do. And we also know that, and I've just set forth the statistics regarding students who've experienced non-consensual penetration or sexual touching. Oh, and I think okay, I'm sorry about that. It looked like the presentation just disappeared for a second. So I've included the statistics on the percentage of undergraduates, the percentage of transgender, gay, queer, nonconforming undergraduates who have experienced these types of sexual misconduct. And again, we see the PGQN in female undergraduates experiencing or suffering the same, but suffering sexual misconduct at about the same percentage rates. And you'll notice the group who's experienced the least amount of the sexual misconduct are male graduate students. And the TGQN from in this presentation, the definition that I just used is actually from that study itself. So that's what was the term that was used in the study, and so that's what I put in the presentation. If you have any questions about that, I haven't been able to find any studies regarding those who are most at risk to sexual violence based on ethnicity, but we do have some statistics regarding the general population, and those are in this slide that's in front of you. Excuse me. We also know that those who are most at risk are those who are newest to the university setting. So we know that freshmen and sophomores are specifically risk for sexual assault and violence. The risk of non-consensual sexual contact decreases as students go from freshmen to seniors at university. We also know that 84% of women who report sexual coercion state that it occurred during the first 4 semesters on campus. There's also a time of year we know when students are more at risk for suffering sexual misconduct, and that's in August, September, October, and November. That's when 50% of all sexual assaults occur on campuses. So you may have heard the term red zone, or even I think in The Hunting Ground, if you haven't seen that documentary, it's very eye-opening. It's something that I highly recommend you see. And it talks about when students are most at risk. We also know that members of Greek organizations on campus are more at risk, and that includes sorority members. And part of the reason for that is related to something else we know is that many times drinking is associated with sexual assault. 78% of sexual assaults involved alcohol, we know, and 1 in 3 victims were drunk, passed out, or asleep when they were assaulted. So as members of sororities, at least what I've read is the thinking is that sorority members attend fraternity parties more often, and as we know, there's often drinking at these parties, so that's why sorority members may be at particular high risk. We also know that the frequency with which women attend fraternity parties is also positively associated with being a victim of sexual assault, and specifically incapacitated sexual assault, which is, as I mentioned at the beginning of the presentation, when a victim is passed out, is under the influence of drugs or alcohol, or asleep. And I hope that this information helps you if you are involved in training or education, just so that it's clear that we're talking about how you can think about your training or think about educating your students. We also know that those most at risk are survivors of prior sexual assault, victims of dating violence, students with disabilities, and for some reason, female students in the Midwest. Now, I also want to talk about what we know about perpetrators. The majority of perpetrators are male. Men are responsible for the vast majority of both male and female rapes on campus. We also know that most of the offenders are actually serial offenders. So, and I find this pretty astonishing, but this is what is shown by the research and data. Of the men who committed rape or attempted rape or admitted to doing it, 63% said they committed an average of 6 rapes each. And we also know that there seems to be a lack of recognition of what comprises rape or what is defined as rape. And we know that 1 in 12 college-age men admit they've basically fulfilled the prevailing definition of rape or attempted rape, yet they don't regard it as such. None of them identify themselves as rapists. So again, in training and education, I think it's very important to understand what appears to be the lack of understanding, especially within male perpetrators, as to what rape is and what consent means. Again, more information on perpetrators. 20% of college-aged males report they obtain some kind of sexual contact through coercion. 23% of male students reported using alcohol or drugs to obtain sexual intercourse. And studies also show that men who are heavy drinkers are more likely than other men to report having committed sexual assault. We also know that fraternity men are more likely to perpetrate sexual assault. And in fact, over a quarter of all incapacitated sexual assault victims report that the assailant or the perpetrator was a fraternity member at the time of the incident. So there appears to be a very big disconnect between, understanding of rape, understanding of what it means to obtain consent, understanding of the fact that a victim is incapacitated has rendered him or her incapable of consent. And again, I think that the training at universities and for all of you who are involved in that, I mean, there is some training about staying safe, but it seems to me that there should be a big effort to correct this, what seems to be a disconnect, and there should be education and training for those who the data shows are perpetrators on rape and perhaps in specific communities that have been identified as where perpetrators are coming from more often than not. I also want to address intimate partner violence. And this is, and again, I took this term from the 2015 study because it did provide some data on who is most at risk and the behaviors that constitute intimate partner violence. This includes violence within relationships, and that means not just couples who are married. It can include casual relationships, people who are dating. Sometimes students refer to this as hooking up, but those can be regarded as romantic relationships. And I know that different universities have different standards for determining what constitutes, let's say, dating violence or intimate partner violence. But these are some of the relationships in which violence can occur. We know that women who've been threatened or who have suffered intimate partner violence are 7 times more likely to experience forced sexual assault compared to other women. Approximately 9.8% of the university's student population has experienced intimate partner violence. And the behaviors can include anything from trying to control a victim. I earlier on in my career, I represented a number of women who were victims of sexual violence, and helping them actually get their green cards under the VAWA Act. And I know that there's a whole cycle and circle of abuse that can happen within domestic violence, controlling everything from where a victim spends her time, what she's doing, controlling her money. We also know that some of these behaviors include threats to the victim, threats by the perpetrator to hurt him or herself, to harm others, or to harm children or pets. And 3.9% of those who experience intimate partner violence also specifically experience physical force. And again, I've included, at least based on the 2015 report, those who most often, or who are most at risk for suffering intimate partner violence. With respect to stalking, on this slide are the different behaviors that are associated with stalking. We know that approximately 4.2% of the university student population has suffered from stalking. Again, I've provided information based on the study that talks about those who most often suffer stalking. It's pretty consistent with those who are at most risk for the other sexual assault and violent behaviors. And I also provided information about who the offender most often is. And again, we see that over 63% of the time it's another student, and it's often a friend or acquaintance. There's a very low reporting rate of sexual violence, and I think if you've been in this, if you've worked in this area for a while, we're all well aware of that. The American Civil Liberties Union estimates that at least 95% of campus rapes in the United States go unreported. And we also know, and again, this is based on that very recent study, that reporting rates to any institution, and that includes law enforcement, victim services, Title IX offices, is very low. And in fact, only 25% of rape cases, those in which a victim was physically forced and was penetrated, only 25% of those victims report to any type of institution. The reasons that students who are victims of sexual violence give for not reporting, they believe that they wouldn't be taken seriously. And that's true even for victims of rape. Over 58% of students gave this reason for not reporting. About a third of students say they'd be too embarrassed or it would be too emotionally difficult. Over a quarter said that they didn't think anything would be done about it. And 1 in 5 stated that they feared reprisal or retribution. So again, for those of you who are involved in training, I think it's very important to address these thoughts that victims have, to encourage them to report, to provide services that support them, and to just provide more education about what the reporting process is like and what their options are. I was very surprised by, again, this 2015 report, what it revealed about bystander intervention, and it also looks like there could be a lot of, would be a great area for increased training and education. 77% of students who witnessed a drunk person heading to a sexual encounter didn't do anything about it. We know that female undergraduates are most likely to intervene, and they are also the most likely to suffer from sexual violence. And of those students who did witness someone acting in a sexually violent or harassing way, over half of them did nothing. So I think there's a lot of room for improvement with respect to bystander intervention, and I know that's a big focus of the Clery Center, and that's been identified as one of the best ways of helping prevent sexual violence from occurring on college campuses. I hope this is helpful. I just listed the sources for that information if you're interested, or if you'd like to learn any additional information or questions about that. I'm more than happy to try and answer your questions. And I guess I just wanted to pause for a moment and see if anybody does have questions about sort of the data and what we know about victims and perpetrators and rates of reporting.
Hi, Monica. This is Laura. There haven't been any questions per se that have come through so far, but there was one comment just about, I believe there was a stat that you mentioned that was, according to one of our participants, felt like the language could be perceived as a little bit victim blaming, so I didn't know if you wanted to address that. They mentioned how the language was, you know, you drank alcohol and you went to a party, so you positively associated with sexual assault. So they were just noting that that could be perceived as victim blaming, and so perhaps if you could speak to that a little bit more, maybe speak to what the research was trying to communicate in that moment.
Oh, absolutely, and thank you. I appreciate that comment, and it was in no way meant to be victim blaming. I was just, I just wanted to, I think it's helpful to know the circumstances surrounding sexual assault and sexual violence, and most of the training that seems to be most needed is that, frankly, to not prevent you from being a victim, but to prevent you from being a perpetrator. So I hope that helps clarify what the intention there was, and I was just providing the information so that we know who the most at-risk population is. And I hope that was helpful.
Yes, great. Thanks,
Okay.
Monica.
So now I'm going to get in.
Oh, sorry.
Go ahead,
the participant just said that they knew that that wasn't the intent, so that's why they were drawing attention to it so that it could possibly be reworded for any future use. That was great. But yeah, go right ahead.
All right, so now I want to dig into sort of the legal nitty-gritty. And this presentation is really talking about two federal laws, two federal statutes. The first is the Jean Clery Disclosure of Campus Security Policy and Campus Crime Statistics Act, and that's a mouthful, so I'm going to refer to it as the Clery Act. And the Clery Act, just as a kind of a high-level description, requires policies and procedures for sexual assault, and it also requires timely warning and external reporting of crimes. Now, Title IX is Title IX of the Education Amendments of 1972, and just in general, it prohibits discrimination on the basis of sex in educational institutions. So I'm first going to address the Clery Act. So the Clery Act really only applies to post-secondary institutions, so colleges and universities. And institutions have to comply with the Act if they're participating in any kind of student financial assistance program. The Department of Education Office for Civil Rights, or sometimes called the OCR, enforces the Clery Act, and the consequences for not complying can be pretty hefty. The fine per violation is over $54,000. That fine amount was recently increased with the stated goal of deterring violations of the Act. The Department of Education can also limit or suspend federal student aid for your institution. The largest fine that was ever levied thus far was in response to Penn State's handling with respect to the Jerry Sandusky on-campus sex offenses. And when talking about the legal framework of both the Clery Act and Title IX, there's a statute, there are implementing regulations, and then there is guidance. As a lawyer, I always look to the statute first, and it can get a little bit complicated. So I strongly encourage any of you who have questions about practical implementation of the Clery Act to reference the Clery Center materials, and also the Department of Education has a wonderful resource, and it's the Handbook for Campus Safety and Security Reporting. It's very easy to understand. It's written in very clearly, and it goes step by step through all of your requirements for reporting. And that is available online. If you don't already have it, I strongly recommend you download it right away. So under the Clery Act, there are different requirements depending on if you have a campus safety or campus police department, and if your institution has on-campus student housing facilities. These slides just provide general information about what is required. What I really want to focus on is what the 2013 VAWA Act now requires with respect to the Clery Act. In that reauthorization of VAWA that happened in 2013, there were procedures and requirements regarding dating violence, domestic violence, and sexual assault. I believe the sexual assault requirements were already there in the Clery Act, but the reauthorization of VAWA added some additional requirements that I want to go over and make sure everyone is familiar with. There are also, before I get into some of those specifics, I also wanted to discuss or just to provide some information on the reporting requirements and with respect to geography. And this slide provides a very, very general overview of what those requirements are. And if you have any questions, please submit them. I'm not going to go over this in detail. So the Clery Act requires reporting of crimes. And there are 4 general categories of crime statistics that universities have to report on. One of the categories is criminal offenses. And those criminal offenses that are specific to sexual violence, which is the topic of this presentation, they include sexual assault, rape, fondling, incest, and statutory rape. These terms they have specific definitions, and I encourage you to refer to the handbook that I just mentioned, the Department of Education's handbook, so that you understand what those definitions are and what's required of you with respect to reporting. The Clery Act also now incorporates VAWA offenses, and again, these have specific definitions, and the VAWA offenses include domestic violence, dating violence, and stalking. Under the Clery Act, an institution has to include the number of reported offenses without regard to the outcome. So that means even when a sexual assault is reported to you, but it's there's no subsequent criminal procedure or disciplinary procedure, it still has to be reported. And I also just wanted to specify that you have to include the count in the year of your report and not with respect to when it occurred. And again, I just want to point out there are very specific definitions of all of these terms in the Clery Act, and all institutions should familiarize themselves with them so that they know what is required of them in terms of reporting and policies. So I've been talking about this reauthorization of VAWA that happened in 2013. There are very specific requirements set forth in the language of the reauthorization itself. And it's pretty dense, but I highly recommend you read it, just at least go over it once. And these slides are meant to sort of highlight some of the key takeaways, the key requirements for under the Clery Act, which are specific to sexual violence. And again, we're talking about rape, sexual assault, and the VAWA offenses that I just described. Excuse me. So the Clery Act now it requires that there be education programs to promote awareness of sexual assault, and that includes both primary training and programs, so that when new students or new employees are coming in, that sort of training and education is provided to them. And there also has to be ongoing training for students, for sophomores, juniors, seniors, graduate students, and also for employees or staff or faculty who've been at the institution for a while. Universities also have to identify sanctions or protective measures they may impose following a final determination in a disciplinary proceeding, meaning that if a student who is accused of sexual assault is in fact determined responsible or is charged with sexual misconduct, there have to be stated sanctions. There have to be stated consequences. Universities also have to provide in writing procedures that victims should follow, and those procedures need to include the importance of preserving evidence and to whom victims should report, and other options regarding law enforcement and campus authorities. The Clery Act also requires that victims be provided a written statement regarding their rights, including orders of protection, no contact orders, and the like. Those are sometimes referred to accommodations or interim measures. And it's codified in the Clery Act that any kind of procedures or disciplinary actions have to be prompt, fair, impartial, that any type of investigation be conducted by officials who are trained, who receive annual training related to this different types of sexual violence. And also the accuser and the accused are entitled to the same opportunities during an institutional disciplinary proceeding, and that includes the opportunity to be accompanied by an advisor of his or her choice. So again, just key takeaway, the disciplinary procedure has to be prompt, it has to be fair, impartial, and it has to be conducted by someone who is trained, and that both the complainant and the respondent are entitled to the same opportunities during the proceeding. Additional requirements under the Clery Act include that both the accuser and the accused are simultaneously informed in writing of an outcome and procedures for appealing the results. If an appeal is allowed, there has to be information about how your institution will protect the confidentiality of victims. You also have to provide written notification about counseling, health, mental health, and advocacy services, and also legal assistance services. And a university also has to provide victims with written notification about their options for changing their academic or living, transportation, or working situations if such a thing is requested by the victim and if it's reasonably available. And again, these measures are sometimes referred to as accommodations or interim measures. So I guess this would be a good time to see if anybody has questions about the Clery Act and what it requires with respect to sexual violence. I realize this is kind of a high-level review of the Clery Act.
Sure. So this is Laura, Monica. We haven't gotten any specific questions. There was one question that came through that was just asking how can we ensure that our schools are following the guidelines for our students. So I just asked a clarifying question about what is meant by we in that question. Just as there can be many different types of responses. If you're talking about we as professionals in the field, how can you all ensure that schools are following the guidelines? It really there needs to be an institutional response to Clery compliance, and that oversight at the institutional level of compliance is that check and balance to ensure that schools are taking into account all of the guidelines that are presented. If you're talking from the perspective of parents or students, there's certainly some advocacy pieces that can be involved there. There are some questions that can be asked at that level as well. I think the challenge here, if I'm reading the question correctly or interpreting it correctly, is that oftentimes there is just a lack of resources at an institution to have the role be one where you are both executing the compliance and overseeing the compliance. So perhaps the question is asking for information around how do you balance that, or how do you navigate that. So I want, I want Monica to have a chance to respond to that as well. And there was also a question that came through that says, would you recommend putting the information that Clery requires into the intake form that an alleged victim completes when speaking with the Title IX coordinator? And so I guess, answer I would say to that is it sounds like you're asking for if a reporting system should be in place that accounts for both Title IX and Clery requirements. And I would say yes, that is the most helpful, to use one standardized reporting form across, if you are a CSA or a responsible employee. That way you can capture all of that information that Clery is asking for within a document that you're using for a report of sexual violence. Sorry, Monica, a bunch of questions are coming in right now, so I just want to make sure we touch on some of these pieces. One of the questions is very specific. It just says the sexual violence definition under Clery is strictly sexual assault, rape, etc., not dating violence, stalking, correct? I was a little fuzzy on the separation, and Title IX lumps it all under sexual violence, correct? So the Clery Act accounts for the terms, the idea of sex offenses in its Clery statistics, and sex offenses captures rape, incest, statutory rape, and fondling. And when you are talking about the prevention work that needs to be in place and the response work that needs to be in place for Clery, you are talking about sexual assault, which captures rape, yes, and then you are talking about dating violence, domestic violence, and stalking as well. So I'm sorry, I should have made this clear. Your Clery statistics capture statistics for sex offenses, which is one term that captures rape, fondling, incest, and statutory rape. Each of those crimes must be broken out, as well as dating violence, domestic violence, and stalking. Each of those acts needs to have statistics in your annual security report. And then in terms of what sexual assault captures, sexual assault is defined specifically by the Clery Act as well, and sexual assault is defined as anything that meets the definition of rape, incest, statutory rape, or fondling for Clery purposes. Title IX's definition, or what you're concerned with Title IX, is anything that falls under the definition of discrimination on the basis of sex. And so what has evolved over the years is that when you are talking about sexual harassment, sexual violence is the most extreme form of sexual harassment. And sexual violence and sexual harassment capture actions that are not captured under Clery, both under statistics or prevention work. So things like sexual harassment or sexual exploitation or exposing oneself, all of those things are things that would be captured under Title IX but would not be captured under Clery. So I hope that provides some clarity to that. Monica, would you like to respond to any of those questions?
I think you did a fabulous job. And I will get into a little bit more about what Title IX prohibits sexual discrimination, which includes sexual harassment, and sexual harassment includes, as you said, the most extreme form of sexual harassment is sexual violence. So that's what all falls under Title IX.
Great, awesome. Thank you, Monica.
I think another question came through. Laura, did you want to address?
Yeah, sure. So I think it says ultimately it would be both a Clery Act and Title IX violation for a college to withhold information on a victim's right, i.e. the opportunity to seek out a confidential advocate, et cetera. So so both Clery and Title IX call for a prompt and equitable process. Clery is way more specific about what needs to actually happen functionally at the institutional level to execute that parameter. And so one of those things is providing in writing to victims that come forward, victims of sexual assault, dating violence, domestic violence, and stalking, both students and employees, a written explanation of their rights and options, which includes information on how to report, information on how to obtain medical services, information on how the disciplinary or conduct process works at that institution, as well as options to seek out accommodations or protective measures. So yes, it would be a violation of both Clery and Title IX, technically, for a college to not provide information on a victim's rights and options, but it's more clearly a violation of Clery, as Clery's requirement to do that is codified into law, federal law. I think we can go back to you, though, now, Monica, so you can continue with your content.
Sure. I think there's also a question about where students can access annual security reports.
Yes, I see that. Yeah, so annual security reports can be available. It depends institution to institution. That information is usually put out or published by a public safety office or a campus police department, or if a campus has a Clery compliance individual or office, it would come out of that office. It also might come out of an equity office. So my recommendation, honestly, is to Google the name of the institution in question and annual security report, and then it should become clear how to get it. But institutions are required to notify the campus community each year when that report is updated and available, and they must do that by October 1st. So that deadline is fast approaching this year. Hope that helps to answer that.
Great. So if we don't have any further questions on the Clery Act, I'd like to launch into the Title IX portion of the presentation. And Title IX prohibits discrimination on the basis of sex in any education program that receives federal financial assistance. So any school who receives federal funds from the Department of Education has to comply with Title IX. And unlike the Clery Act, the Title IX actually applies to primary, secondary, and post-secondary institutions. So that includes the K through 12 education setting as well. Title IX is enforced by the Department of Education Office for Civil Rights, just like the Clery Act. Penalty of violating Title IX is removal of federal funding. Unlike the Clery Act, there's also the availability of private lawsuits against universities and schools for violation of Title IX. Litigants can bring claims for monetary damages, equitable relief, and if a university or a school is found in violation of Title IX, that would include attorney fees. So any institution that's found liable for violating a student's Title IX rights could also be on the hook for paying the plaintiff's attorney fees. There are different standards if you're talking about the Department of Education's sort of administrative enforcement of Title IX as opposed to what a federal court looks to in terms of the case law and the legal standards that establish universities' responsibilities and liability under Title IX. So again, much like the Clery Act, we have sort of different levels of law and guidance. We have the statute itself. We have the implementing regulations, which are much more sparse than those for the Clery Act. We also have a lot of federal case law. I think if you turn on the news or read any kind of newspaper, you're probably going to see something about a Title IX lawsuit. Baylor has been in the news quite a bit lately. There's also extensive guidance from the Department of Education Office for Civil Rights. So even with the withdrawal of the Dear Colleague letter and questions and answers on sexual violence, there's still guidance available on the Department of Education website, and I'll go over a couple of those that I refer to quite often. So these are all the different, and it may seem a little bit overwhelming, but this is everything that we look to in determining what a university's responsibilities are. The purpose of Title IX is to eliminate discrimination on the basis of sex in education programs. And when we talk about sex discrimination means sexual harassment. So under Title IX, you see a lot of discussion about what is sexual harassment. And pursuant to case law and guidance, it is well established that sexual harassment includes sexual violence, which is rape and sexual assault. And Title IX prohibits both student against student and employee against student sexual harassment. So, that includes one student sexually assaulting another student. That could include a professor raping a student, as well as other staff and employees of a university. This is the Department of Education's 2001 guidance with respect to what constitutes sexual harassment. So Title IX prohibits a very broad range of sexual harassment and sexual discrimination, and that includes what's described in this quote. But what I'm going to be talking about, and what we have been talking about, is that sexual violence on the one end of the spectrum of sexual harassment. And again, I want to make clear that sexual harassment can include gender-based name-calling and all kinds of behavior. But today we're just discussing, rape and sexual assault and what Title IX requires in those instances. As you may know, on September 22nd, so just last Friday, the Department of Education withdrew two guidance documents on sexual violence, and in doing so, the Department of Education specifically referred schools to the Q&A that came out simultaneously with withdrawal of the Dear Colleague letter and the 2014 Q&A. So now there's a September 22nd, 2017 Q&A on campus sexual misconduct. The Department of Education also referred universities to the 2001 revised sexual harassment guidance, and in 2006, the Department of Education issued a Dear Colleague letter that reminded universities of that 2001 revised guidance. The Department of Education also refers universities to Title IX itself and the implementing regulations, which I'm going to go over. And the implementing regulations are not super complex. As you probably all know, university has to designate a Title IX coordinator. This is a responsible employee who coordinates efforts to comply with and carry out a school's responsibilities. A university has to notify students and employees of the name, office address, and telephone number for the Title IX coordinator. And it's surprising how often that doesn't happen. I do see a lot of schools doing a great job with that, but this is a regulation. This is sort of a black letter law about what's required just with identifying who your title coordinator is. And that's, of course, as you can understand, very important because students have to know who they can report sexual violence to. Again, we see mention of the prompt and equitable resolution of complaints. So schools have to adopt and publish grievance procedures. And schools also have to implement specific and continuing steps to notify the school community that it doesn't discriminate on the basis of sex. I often see a lot of boilerplate about this. I do work at the K through 12 level, and oftentimes you'll see in the student handbook some boilerplate language. But what's very helpful is if any type of notification also includes examples of what constitutes sexual harassment. Again, I don't see that so much at the university level, but to the extent that you haven't, included examples of what sexual harassment is, I would encourage you to do so. So that's the regulations. We know what the statute says. We know what the implementing regulations state. And this is the guidance we now have from the Department of Education, Office for Civil Rights. So in the January 25th Dear Colleague letter, which the Department of Education did point to as guidance that continues to exist, a school is obligated to take immediate and effective steps to end sexual harassment when it occurs, prevent its recurrence, and remedy its effects. And this is when a school either knows or reasonably should know about an incident of sexual misconduct. And the school has to take steps to understand what occurred and to respond. So the school has to undertake an investigation, whether receives a direct report of sexual assault, or whether it reasonably should know of an incident. And examples of should know include maybe if there's a rumor about a sexual assault, if a victim isn't directly reporting to the school, but somebody is saying, I think this may have happened. A school is still obligated to figure out what happened and to respond quickly, immediately, and with effective steps. And that continues to be the guidance. That last requirement, the reasonably should know or knows, was set forth in that September 2017 Q&A that just came out. Schools' duties also include determining whether a hostile environment exists, and we'll go over what hostile environment means. Again, there are lots of terms that are used in the guidance that is very important to understand. Schools responsible for addressing a hostile environment that occurs on campus, even if it relates to something that happened off campus. So an example of that would be if a sexual assault or rape happened off campus, and again, this is just an example, and the perpetrator and the victim are both students at the school. So that would obviously affect the on-campus environment, and would very likely constitute a hostile environment. The September 2017 Q&A that just came out specifies that addressing allegations of dating violence, domestic violence, sexual violence, schools have to comply with both Title IX and the Clery Act. And again, I just want to emphasize there are different requirements for both of those laws, and schools have to comply with both of them. The Q&A also mentions interim measures, so those are, I refer to those as accommodations. Interim measures should be offered to both the reporting and responding party. This is a little bit different from previous guidance. I think previously it wasn't specified that interim measures had to be offered to the responding party. We know that different interim measures that can help prevent victims are stay-away orders, and it's helpful to think about where students may, where a victim and an assailant may encounter one another. That can be very traumatizing for victims. So I've seen stay-away orders that take into consideration library use. So in some instances, if a victim knows that he or she, wants to use or regularly uses a library at certain days of the week at certain times, there can be a stay-away order put into place to make sure that the two students don't encounter one another. You may want to take into consideration if students have the same classes together, what kinds of accommodations you can make to victims so they don't have to attend a class with the assailant. And there are number of very fact-specific considerations to take, or specific facts to take into consideration in designing good interim measures that protect students. Also, sometimes, as we know, in discussing the impact of sexual violence, oftentimes victims will, their academic performance declines. So another interim measure that we've requested from universities is that students be given some lenience and maybe be allowed to take tests again or even retake a class. You see a lot of mention of prompt and equitable. And the September Q&A that just came out from the Department of Education talks about that. There's a lot in writing. Again, it's primarily about making sure that the process is fair, that students have notice of what the procedures are and applying those grievance procedures, conducting a reliable and impartial investigation of complaints, and that where both parties have the opportunity to present witnesses and other evidence. So whatever is afforded to one party has to be afforded to the other. And I think most schools were already doing that, but the Q&A emphasizes that. The Q&A, the new standard, or what was just put out by the Department of Education, is a little bit different. The Q&A specifically withdrew the 60-day investigation time frame requirement for investigations. There's no fixed time frame within which a school needs to complete an investigation, and in determining whether a school's response is prompt, the Q&A now states that the Office for Civil Rights will evaluate the school's good faith effort to conduct a fair, impartial investigation in a timely manner. I guess one of the questions that I would, or something that I would really like to know from all of you is whether this is helpful. The Q&A seems to take away a little bit of clarity or guidance with respect to what is a prompt time frame. And I'm just wondering if, from all of you if that's actually helpful or not. With respect to equitable, again, the Q&A that just came out emphasized that an investigator has to be trained, that he or she has to really document everything to be objective. I think most universities are doing a really great job at that already. Again, the rights or opportunities made available to one party have to be made available to the other. There was one provision in the Q&A that I admittedly am a bit confused about, and that is with respect to what the Q&A described as gag orders. What I find a little bit problematic is balancing that with the right of a student to proceed confidentially. And we know that schools are also obligated to maintain the confidential nature of confidential information regarding victims. So I am very interested to see what is going to happen with respect to that. And again, I highly encourage you to review the September Q&A yourselves, along with the letter that came out with the Q&A. More information on what the OCR is going to view as equitable. Again, there's a lot of written notice, written report, documenting everything you do, and making sure that both parties have equal access to information. The Q&A sets forth procedures. Again, some of these are the same. The biggest difference with respect to grievance procedures is that the OCR no longer requires schools to utilize a preponderance of evidence standard, which was basically is more likely than not. That is the same standard that's used in civil lawsuits regarding like tortious battery and assault. And the OCR now indicates that schools can use either the preponderance of evidence standard or the clear and convincing standard. And sometimes this is confusing even for lawyers. But that's a way to describe what is clear and convincing is if there's a firm belief or conviction that it's highly probable that the factual contentions of a claim are true. And the OCR states that any standard for sexual misconduct has to be consistent with the standard applied in other student misconduct cases. So if in your regular practice regarding student misconduct that doesn't involve sexual misconduct, you use one of these standards, you now have to also use that for sexual misconduct as well. Again, there's a heavy emphasis on written notification regarding the outcome, actually regarding every stage within an investigation, and that's set forth in the Q&A too. I just wanted to briefly address hostile environment, and basically that's when misconduct is serious enough that it limits the victim's ability to participate in or benefit from the school's program. We know that with even a single isolated incident of rape or sexual assault creates a hostile environment. That's pretty consistent. All federal courts, almost all federal courts, with the exception of a case that just came out of the 8th Circuit, most of them regard a rape as creating a hostile environment, pretty much de facto. But these are other considerations. If a school is investigating other types of sexual harassment, these are the factors that that your school should take into consideration if you're trying to determine whether a hostile environment exists. there is the Department of Education Office for Civil Rights still does have some additional guidance, even though it withdrew the Q&A and the DCL on sexual violence. There's a really great resource available, and it's the Dear Colleague letter that's specific to Title IX coordinators, and there's a Title IX resource guide that's available online. There's also a Dear Colleague letter regarding retaliation that I find very helpful and that I refer to. And as you all probably know, it's unlawful to retaliate against anybody who reports sexual assault or sexual violence or participates in an investigation. So that's all. That's the guidance, and hopefully that provides you with some basics regarding requirements at the disciplinary level and what the Office for Civil Rights is going to look at in determining whether you fulfilled your responsibilities under Title IX. And as I stated before, Title IX is also enforced in the civil litigation context. Individuals can bring private actions for monetary damages and equitable relief for violation of Title IX. And the courts look at different standards. The standard is heightened once you get to federal litigation. And I'm just briefly set these forth in the slide here. Unlike at the administrative level, where a school is responsible for investigating sexual harassment if it knows or reasonably should know about it, federal courts require that a school or university has actual knowledge of sexual harassment. And so that comes from the U.S. Supreme Court. Some of the federal circuits have different standards with respect to what actual knowledge means. But usually at the university level, unlike the K through 12 level where I do some litigation, usually do you have reporting, even though we know the rate is pretty low, you do usually have reporting of sexual harassment. And in federal court or in civil litigation, the standard is whether a school was deliberately indifferent to sexual harassment. And that's usually defined as a response that's unreasonable in light of known circumstances. Deliberate indifference is also found if a school even does take some action, but knows that it's not effective, that same sexual harassment or behavior is continuing. And one of my colleagues describes this as sort of the Einstein theory of liability or deliberate indifference. If you just do the same thing over and over, expecting a different result, that doesn't quite wash. So that's a much higher standard in the civil litigation context than a school reasonably responding and what's expected of a school in the administrative context. The last required element in a Title IX lawsuit is when sexual harassment is so severe, pervasive, and objectively offensive, it could be said to deprive a plaintiff of educational opportunities or benefits. And this is usually one incident of rape or sexual assault meets this requirement without having to show anything else. But as we do know, and I already went over, sexual harassment, sexual violence usually has really tragic consequences on a student's academic performance or on his or her access to educational opportunities and programs. This is just a quick rundown. Again, this isn't legal advice. If you receive a report of sexual violence, you have to do something. You have to investigate and take the steps to resolve it. Just check through all your reporting and other obligations under the Clery Act. Address the interim measures. Document what you're doing. Make sure that any opportunities to present evidence are presented equally to the complainant and the respondent. even in the 2001 revised guidance that the Department of Education just recommended that schools look to, that revised guidance states that police investigations or reports can be useful but aren't determinative of whether harassment occurred under Title IX, and that's because there's a different standard. As we know, in the criminal arena, the standard is beyond a reasonable doubt, and in determining responsibility, student responsibility under Title IX, in the administrative arena or in the disciplinary proceedings, the standard is clear and convincing or preponderance of evidence. And again, just make sure that everything is in writing. So I guess this slide kind of summarizes the takeaways. Be aware that sexual violence has devastating consequences. Think about the red zone and how you might want to, focus training or education with respect to what we do know about victimization and sexual assault. The Clery Act and Title IX are separate statutes. They're separate laws, and schools are obligated to comply with both of them. Try to make sure you have the right procedures in place, and when you have them in place, follow them so it's not just policy and that you're actually implementing your policy. Doing nothing will always equal deliberate indifference, and that means that you are now into the civil litigation arena, which I'm sure most schools want to avoid. Make sure everything's prompt and equitable, and I think that pretty much concludes my Title IX section. I'm wondering if anybody has any questions.
Hey, Monica, this is Laura. So before we answer a couple more questions, you'll just notice that, you'll notice that we just posted a link to a feedback survey that we asked you complete before the end of the webinar today, if you get a chance. If you do complete it, you have the option to then enter into a raffle for a registration for a free online Clery Act training. Just wanted to say that quickly. Monica, I know that you had asked earlier how folks were responding to the rescinded guidance taking away the idea of a clear-cut time frame for the goal for completing those investigations. There have been a series of comments around it, and I would say I think I would helpfully summarize them all by saying most people seem to say that it would depend, like they can see the argument for not having a time frame if it's going to, only hamper an investigation, but some folks are saying that with the help of a time frame, that means that you have a standard by which you should aim for. There was always the ability to say that you could extend that time frame, especially in the case of if a criminal investigation was ongoing as well. But the intention with the application of that time frame was to ensure that cases were not going on for a ridiculously long duration as to not be helpful. So it seems like most folks are saying that some definition, some parameter is more helpful than not because folks can easily then abuse not having a time frame. And then I think there was another question. I must be missing it now, but those are a lot of the thoughts around that. I didn't know if Monica had any other, if other folks had any other questions for Monica, but in the last few minutes here of our webinar. Yeah.
Well, again, and I realize that was pretty quick, and I would be more than happy to answer questions. If you want to separately email me, I provided my email address on the last page of the presentation. So if you want to give me a call or send me an email, I would be more than happy to try to answer your question. And I just want to thank everybody who participated in this call. And I wish all of you a really wonderful day.
Great. Thank you so much, Monica. I do think there is one more question that we could take before we end. There's a question that said, are institutions typically addressing the September 2017 guidance with a footnote within their ASRs or added provision suggesting that changes to policy and procedures will be undertaken to follow the new guidance? So this is something that, I think a lot of folks are talking about right now. I think there is a lack of clarity as to whether or not institutions should make significant changes at this point, as the guidance that was issued on Friday is intended to be interim guidance. As OCR and Ed has announced that there will be a notice and comment period for the purpose of then, putting all the thoughts and ideas from the pre-existing DCL, the current DCL, former and current Q&A, into an actual, guidance that has gone through public comments, like the 2001 guidance. So I would say I do not know of any institutions right now that are looking to put any language in an ASR that they will be changing procedures to follow new guidance, because there has not been technically official new guidance. There has been interim guidance provided currently. And as we've been saying, as the ASR really is focused on Clery requirements, there's nothing in the guidance from OCR on Title IX that prevents institutions from implementing Clery Act regulations, which covers a lot of these pieces. I know that there is a webinar taking place, tomorrow, jointly held by NAFSA and the Association of Student Conduct Administrators, that possibly will address, how institutions should or maybe already are handling some of the guidance that was issued on Friday. But I do open that question out to the rest of the group if there's anybody else that has already started to maybe make any changes based on the guidance, or include any language in their ASRs around undertaking changes because of the guidance. ASRs are required to be published by October 1st, which is an impending deadline. So I do put that question out to the group if there's anybody that wants to answer that before we close in the next couple of minutes. And I'll just look to see if anybody shares any answers with us. But in that meantime, thank you so much, Monica and Sophia Berg National Law Group, for joining us this NACSAM and for today's webinar. Monica, there is a question in the private Q&A directed for you, so just wanted to draw your attention to that as well. And sure, the webinar name for tomorrow, let me just look that up really quickly. I know you can access it just by going to NAFSA's website or ASCA's website, or looking at their statements that they put out on Friday. The exact title, I believe, is Title IX Turmoil, Initial Analysis and Next Steps After the Withdrawal of the 2011 Dear Colleague Letter. So if you are looking for that, you can join that webinar by going to NAFSA or ASCA's website. Great. So Monica, if you just want to hang on the line to just answer this one question, that would be great. And there's also, that's correct too, sorry, I didn't mean to cross-advertise. There is also a webinar we are holding tomorrow in conjunction with IACLEA, and we just included that link here as well in our group chat. So yes, there is that webinar as well. Thank you all so much for your time today, and we will pass this question on to Monica in case we have to close this platform down. Thank you so much. Thank you, Monica.
Thank you, guys.